Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists. And as uncertified podcast hosts, we try to bring our audience of trial and appellate attorneys some legal news and perspectives they can use in their practice. As always, if you find this podcast helpful, please recommend it to a colleague.
Yeah, if you don't find it helpful, listen to it at double speed next time.
That's right. All right, Jeff, the 2025-26 Supreme Court term officially started last month. And today, Jimmy Azadian has graciously agreed to orient us to the new term and also some upcoming laws, what to look forward to in California that are going to be effective in 2026. Lean in if the audio is too quiet to preview one of them, because there will be no longer any opportunity for us to blast the volume when we get to the more interesting parts. Jimmy Azadian leads the nationwide appellate and critical motions practice at Dykema, working from its Los Angeles and DC offices, and he's the chair of its West Coast appellate practice. Jimmy specializes in federal and state court commercial litigation, especially involving First Amendment issues. More importantly, he is a California appellate law podcast alum, and he is the best connected appellate attorney that I know. Every time I mention his name to a colleague, they tell me, tell Jimmy that I said hi. So Jimmy, you know everybody and everybody knows you. So welcome back to the podcast.
Well, thanks very much, Tim and Jeff. It's always such a pleasure to join you. And not just for podcasts, but for just any conversation. I always enjoy speaking with both of you.
Well, likewise. Jimmy, you have such a great grasp of what federal appellate judges are thinking about. So I thought before we dive in, I would ask you if you can kind of give us a sense of the mood or the tenor of the federal judiciary. I know you're always hobnobbing with federal judges. I think you're talking about the conference, the appellate judges conference that you're attending next week. And I wonder if you can just kind of give us the perspective of a fly on the wall in a room full of appellate judges. What are they talking about? What's the mood? What kind of issues are on their minds all the time?
Well, definitely, I think the subject on almost every judge's mind right now is the independence of the judiciary. That has been a subject that continues to really be the focus of a lot of judicial conferences that I've attended, starting with the Ninth Circuit Judicial Conference back in July in Monterey. And now I know the Appellate Judges Education Institute is coming up next week in Minneapolis. It definitely seems that there is more and more interest in the subject of judicial independence. The separation of powers is, I think, an outgrowth of that discussion. And I think judges are also very interested in the subject of their own safety. As you are probably aware, throughout the country, federal judges have even been getting pizza deliveries, right? And it's really a sad state of affairs because, the message that is being sent is, well, these judges didn't order these pizzas, but somebody now knows where they live. And there have been efforts by the U.S. Marshal Service to hopefully, and prevent, any kind of danger to our judiciary, to our judges. But things have, I think we're reaching a point where, you heard about Justice Kavanaugh and the individual that was found outside his home, right? That was there to plan an attack on Justice Kavanaugh and his family. It's getting to the point where now when I'm inviting judges to come speak, what used to be before an emphatic, yes, I'd love to come to speak to, say, your students at Pepperdine, Caruso School of Law, or to your students at UCLA, or even to a group of the Federal Bar Association. You can tell that there's less enthusiasm around that they're asking questions. Who will be there? What can I expect? They're not outright asking me, is it safe? But I know that's what's on their mind. And so I was very happy to recently host Justice Kagan at a Pepperdine Caruso School of Law. She came and spoke to our students, our faculty. She judged our annual moot court competition. But I can tell you, these were the same subjects that were discussed, over lunch with her. There's a real sense of urgency around these subjects as far as the judiciary is concerned.
Let me ask you this. I wonder if you put these two things in the same bucket as that. You're talking about these recent episodes, very alarming episodes about threats of personal violence, threats to the safety of members of the judiciary. There was another recent flashpoint. When was it? About 2 years ago, when who was the judge who visited Stanford Law School and was treated with great indecorous demonstrations and was basically shut down and prevented from speaking. My recollection is that there was not any violence threatened there. It was just very disrespectful to a member of the federal judiciary. Do you put that in the same bucket? Do you think that is also looming large in judges' minds, or is it limited to actual personal safety threats?
Oh, I think it's both. I do. I think it's both. And I think, Supreme Court justices have a high amount of protection and security. Circuit judges, district judges, they really don't. And so for them to step into these forums and to be so generous with their time and their talents and, be able to speak to the next generation of lawyers and even the current generation and crop of lawyers. What before was really viewed as something special and fun and meaningful, I think, the first layer, the first thought is, as you said, Tim, what am I facing? Right. And I remember years ago, you all do too, when Judge Bybee on the Ninth Circuit went to Harvard, right, to meet with a group of Federalist Society students there at the law school. And he was greeted, well, not favorably greeted, but greeted with a bunch of, students wearing hoods, right? And it really was, a sad thing. Regardless of how you might view a judge's decision or ideology, really, a judge does not have the ability to respond, right? I mean, you and I can write an article, an op-ed, a judge can't. And so if one takes issue with their decision or their decision making, I think it's fine to engage in civil discourse. I think it's fine to, even disagree with respect with that judge's decision, but it's never fine, to attack a judge or to, level threats against a judge or go on the deep web and share that judge's home address. I mean, it's really reached, I think, an alarming level. And I'm not so sure that it's something that has been happening just recently too. I mean, I think even in the, even the past few years, it is almost like when politicians come forward and say things about judges, right, and disrespect judges, it's fine again to disagree with a decision and to say, I disagree with that judge's decision. But to attack those judges or to say that they're not doing their job or they're intolerable, I mean, I think it opens a gateway of criticism and, frankly, potentially attacks on the judiciary that are just simply unwarranted.
So those comments all fall under the rubric of independence of the judiciary. So I think those are well taken comments. What about, from your perspective, are federal judges breathing a sigh of relief now that we're mostly done with the first year of Trump's second administration and the rash of executive orders that caused a lot of consternation among many of us? Are we through that first initial flurry? We through the worst of it, and are we on the better end of the tail on that, or are we bracing for another set of challenges?
Well, I was recently speaking with a number of law school deans about this, and some who are advocates before the United States Supreme Court, and I don't think the temperature has changed. I think federal judges in particular, are definitely thinking that there's going to be more litigation surrounding executive orders. And we're in a very interesting time in our nation's history. There have been presidents before, including FDR, who took a unitary executive theory view of the executive branch. It's not simply conservatives. It's also been members of the other party. And, a strong executive does often command more challenges, core challenges to, the edicts or the executive orders that flow from the Oval Office. But to answer your question, Tim, I think that the Supreme Court, its emergency docket, I don't like to call it a shadow docket, but its emergency docket has become the executive order docket. And that's not just, the state of affairs according to Jimmy Azadian. I think that's just, that's come out of the mouths of various justices that, they are expecting to continue to see a ratcheting up of litigation based on new and current executive orders. Now, that's not a commentary on the unitary executive theory. It's certainly not. I'm not saying that it's a bad theory or a good theory, or that these executive orders are good or bad. All I'm saying is we're seeing an unprecedented amount of executive orders. And of course, that means that they are on contentious hot button issues. And those issues are going to continue to find their way into court. I should also mention that, that might be a good segue into, a subject that I know you wanted me to talk about, which was the Ninth Circuit cases of 2025. What are some of the more notable cases of 2025? And just in July, we had the birthright citizenship executive order come back to the Ninth Circuit. And that was in the case of State of Washington v. Trump. And the reason why I thought that was a good segue is because when we're talking about executive orders and unitary executive theory, here, of course, President Trump has issued an executive order that says that, that really limits citizenship to certain categories. And this was a panel of two Ninth Circuit judges who were appointed by Democratic presidents and one who was appointed by President Trump in his first term. And Judge Gould, who was appointed by President Clinton, wrote for the majority. And the dissent was written by Judge Bumate, who was President Trump's first term appointment to the Ninth Circuit. And what the panel majority did was reaffirm that 2025 executive order attempting to end birthright citizenship. And it said that it was unconstitutional, that executive order was unconstitutional. And it upheld the lower court's nationwide injunctions, even after the Supreme Court's Casa v. Trump decision, and reinforced that children born in the U.S. remain citizens under the 14th Amendment. Well, Judge Bumate issued what he called a partial dissent in that case. And what he does is he reframes the case as a test of judicial restraint and fidelity to Article 3. And he focuses and notes the dangers of judicial overreach in the face of what he calls intense policy controversy. And he says that the role of the judiciary is not to answer every significant or contentious question. And he does question the device of nationwide or universal injunctions. Frankly, I don't think any of us were surprised last term when the Supreme Court kind of put an end to the universal and nationwide injunctions with limited exceptions. But he questions those universal injunctions and that device. He does not find historical support for them in terms of their scope and their breadth. And he also says that the states do not have standing to bring a challenge to that executive order because there's what they've claimed as fiscal injuries are much too speculative. So the reason I start with this case for you is because I think what it highlights is more of an approach of the two different approaches that you find in the judiciary. One, where they look at these questions more as political, and you've got judges that are saying, we don't think this is our area. This is our lane. This is a political question. It's controversial. This should be decided by the elected officials, right? And then you've got judges who say, no, this is exactly what our job is. It's to interpret and to apply the law, the Constitution, to this set of facts. And is this case going to go up to the Supreme Court? I mean, I think so. I think it will. At least a case like this will. And, the Supreme Court punted on the birthright citizenship question, the core question. We know it's just a matter of time before the Supreme Court weighs in on it.
That's interesting that I wasn't aware of Judge Bumate's dissent, or you called it a partial dissent, or the standing question. The way you describe it sounds right to me, that a state's fiscal impacts probably are too speculative to give a state standing to sue over an executive order. Certainly individuals would have standing. I noticed there was another standing case on the docket, this involving who has standing to challenge election issues, and do the federal candidates have standing to challenge ballot counting issues? And I haven't looked into the case, but just reading that issue, the question came to mind, if not the candidate, then who? Who's going to have the wherewithal to get up and challenge that before it's too late? Usually even candidates fail to get on the ball before it's too late, because there's a very small window between the time the grievance is known and felt and the time it's too late to do anything about it. And then I can't talk too much about it, but I've got a cert petition pending, and the Supreme Court has asked the other side for briefing on it, involving the question of whether a city has standing to bring federal constitutional challenges against a state, because in the Ninth Circuit alone, among all the other circuits, has a categorical bar that prevents any municipality from suing the state, bringing any kind of federal constitutional claim. So we're bringing that, and there's another related case out of New Jersey, a transit authority suing the state, and a similar issue has come up. So I wonder if there might be a milieu of standing issues in different arenas that are coming up in the court. And I'm knocking on wood that my hope is that they are going to take it, because that would bode well for my own case.
Well, Tim, first of all, congratulations. It's no small feat to get one justice or more justices to wish for a response to a cert petition. So it means your case has legs. You know this better than anyone. It means that you're in the ballpark. So congratulations, and I hope for you that you get a wonderful merits positioning there, and maybe even an oral argument. I wanted to also mention, though, in terms of your focus on standing, or what you see as the Supreme Court's focus on standing, some have called this a renewed focus on standing. Well, many of us were not around yet, but we all know, at least historically through law school, with the Lujan case, right, and Justice Scalia joining the Supreme Court, there was a real focus that started on standing. Article 3 standing. What is an injury? What is an Article 3 injury? What is a case or controversy, right?
Jimmy, who was it who said that the rocks and the trees should have standing?
That's right. That's right. And, I heard these doctrines, described by Judge Santel on the DC Circuit one time at a brown bag lunch that we had with him. And I loved what he said. He said, mootness means, you're too late. Ripeness means you're too early. And standing means none of your business. Okay. And I always loved, I love those shorthand, devices. And I always think of those things. I just wish in law school, when we learned about these doctrines, we could have probably gone home in just a few minutes if someone would describe them, that way.
We should just rename them. Yeah. Just
Right.
give it salt of the earth names instead of, ripeness, mootness, standing. No one understands those.
None of your beeswax. I do think that we're seeing a renewed focus on standing, to answer your question. And where I saw that start to come in really was with the first administration of President Trump, with the the elevation of Justice Gorsuch, to the Supreme Court, and then especially with Justice Barrett. I think, with Justice Barrett, who clerked for Justice Scalia, I think she certainly has a focus on standing, and she's really, I think, bringing her colleagues' attention to those standing defects and those issues. And frankly, I think it's always been an attractive way to duck substantive questions and potentially controversial ones.
But Jimmy, let me push back on that for a second, because it's easy to say, let me just say, I don't agree with a lot of Trump's policies. And it's easy to say there's an increased focus on standing as a filter or a way to duck answering the hard questions. But the Supreme Court is the court that gets to pick its own docket. And they don't have to answer the hard questions just by denying cert. So I don't know if I agree that at least at the Supreme Court level, that standing is a way to avoid answering hard questions.
Well, I think it has a lot to do, Jeff, with how cases are chosen for cert, right? Because unlike other courts, in the Supreme Court of the United States, you don't need a majority to take a case up on cert. You need 4 votes. And so that's not to say that the votes are necessarily there, on the substantive question, or how maybe some members of the court want the substantive question answered. I think a really good example of this is my late boss, Ken Starr, right? When he argued the Pledge of Allegiance case, we all remember that one, came out of the Ninth Circuit, Newdow, and the court took it up on its merits. Does the Pledge of Allegiance violate the First Amendment? And if you remember, the court ended up, deciding the case on standing. And it was Dean Starr, or Judge Starr's argument that was made during oral argument that this, and in his briefs, but he had represented the mother and the child. Newdow said he had standing because he was the father of the child who was forced to say the Pledge of Allegiance in school. Well, Judge Starr came in and said, wait a second, he hasn't paid child support. He doesn't have standing to assert the rights of this child. And the mom's okay with it. And guess what? Done. No standing. The case was dismissed for lack of standing. And some have described, well, gosh, that's maybe because the justices were actually, if they were forced to answer that question on the Pledge of Allegiance, were going to, go in a direction where we would no longer have under God in the Pledge of Allegiance. The Pledge of Allegiance would change. This all speculation aside, I think on the one hand, that is a perfect illustration of where standing is not used as a ruse. Don't get me wrong. Okay. But it is an off ramp, right? If it's there, it's available and it's true, it's an off ramp, it can be used. Secondly, you've got, cases that are taken up based primarily on the standing doctrine. I mean, we've seen those cases in the FCRA context, right? In the consumer reporting context, in the credit reporting context, where judges have said, look, you cannot bring a class action and amass all of these, judges have said, and amass all these damages. If you don't have statutory damages, you don't have a claim under that statute. You don't have an Article 3, injury that is concrete. And so those are the types of cases where the justices are taking core standing questions and doctrine and speaking to those directly. So I think you have both. And my point is that there is a renewed focus on the latter, right? The core standing doctrines, the core standing questions. We're seeing a renewed focus on that. If you want to say kind of like a revival of standing in the Supreme Court.
And I think I would propose a slightly different salt of the earth term for standing than none of your business. I would call it what's it to you? Because that's
Right,
really the
good.
essence of
I like that.
the case or controversy requirement, which is where all these doctrines derive from. Is that there has to be a case or controversy, meaning the litigant there has to be some real world impact to these litigants. So what's it to
Yeah.
you? And if it doesn't really affect your life, then you're just someone else with an opinion. And we all got opinions, but we don't all get to bring our opinions in federal court.
Yeah,
Yeah.
I would call it the halls of justice doors are closed to you doctrine, but that's just me. I have different opinions.
I mean, another way, I mean, there's been so much focus on concrete injury recently, right? Because of the Supreme Court cases, really focusing on that element of standing. But I will say that, I mean, if any client walks into your office, you're probably going to ask them, if they are the claimant or claimants, you're going to say, if we win, what are you going to get? Or what do you want? Right? That's a question and a conversation that probably occurs on the daily in many law offices around the country. So we are asking these questions as lawyers. Why do we not expect our judges are asking the same questions? I know Judge Silberman on the DC circuit, when he was hearing cases, he would buy his law clerk a steak dinner if they found a standing defect. Okay. And it was a good steak dinner. It was a very good steak dinner. It wasn't like, at Sizzler. It was, at the Capitol Grill or, Smith and Walensky or wherever. I mean,
So
that's,
he had those law clerks sniffing out standing
yeah,
defects.
yeah.
He incentivized them.
And I think it really goes to the heart of Judge Bumate's dissent, right? Because he says courts should be courts based on judicial restraint. They shouldn't be overreaching. They shouldn't be trying to answer questions that are not actually tenable, that are not justiciable. And so I'm not taking a position on this case. All I'm saying is that here is a perfect illustration of two schools of thought on that subject.
Yeah. Well, I think that's very interesting. I think that so we'll be on the lookout for that, for more evidence of the court's possible renewed interest in standing, or I don't know if it's exactly renewed or if it's enhanced, and they're continuing to tighten it up. Is it going to Lujan is the operative test for standing, injury and redressability and causation. Are we talking? There's not talk of changing that test. Is it just more strictly applying that test?
I think it's actually that test hasn't really been tinkered with too much. What we're now doing is, I think courts, justices, judges are getting more into the weeds on what is a concrete injury, right? What is an actual controversy? Another element, and I think when you're dealing with what is an actual injury, there's now been more of a focus on statutory injuries, statutory damages. And you could be part of a class action but not actually have a statutory damage or statutory injury. And
Oh, that's interesting.
those are that's what I mean when I say getting into the weeds, right?
Yeah.
You just can't simply be part of a class action necessarily without having an actual injury.
Yeah, well, that's interesting. Does that tee up an issue of separation of powers if a legislature just decides that, well, we want litigants to have standing to bring these claims in federal court. So if someone feels bad for a rock or a tree, we're going to give them nominal damages, and that gives them concrete injury to sue in federal court.
Well, I think those are those are the specific cases that the Supreme Court has heard to date, like the FCRA case, and in that particular case, they said, you can't just wave a magic wand and say you're damaged.
Yeah,
We still have an Article 3 responsibility as
yeah.
federal judges to make sure that there is actually the Article 3 sets the floor, right? Not the ceiling. Congress can set the ceiling, but the minimum requirement of standing requires some concrete, palatable injury that is redressable, not just simply an injury, but that is redressable.
Well, let's talk briefly about another interesting Ninth Circuit case. Jeff and I have talked about this, but I want to get your take on Gopher Media because you, like Jeff, focus on a lot of First Amendment and anti-SLAPP work. And now in the Ninth Circuit, that the shape of these anti-SLAPPs are going to change. I mean, I guess part of the upshot of the panel's decision or the en banc decision in that case is that the SLAPP statute and the shape of SLAPP practice is already different in federal court than it is in state court because of how federal procedural rules have to apply, even though there is some arguable substantive aspect of SLAPPs. Tell us, remind us what happened in Gopher Media, and then we'll talk about what the fallout is going to be, or how anti-SLAPP practice is going to change shape in the Ninth Circuit.
Yeah, I think the fallout's the most interesting part of this discussion. But as a reminder to your audience, SLAPP, of course, is an acronym, and it stands for Strategic Lawsuit Against Public Participation. In this particular case, what was up for the en banc court's determination was the California anti-SLAPP statute. That's Code of Civil Procedure Section 425.16. And it was a unanimous decision. It was authored by Chief Judge Murguia, our Chief Judge on the Ninth Circuit. And it was issued just last month, in October. And it was an en banc panel of the Ninth Circuit, and it held that denials of California's anti-SLAPP motions, so strategic lawsuits against public participation, those motions that are brought in federal court that are denied are no longer immediately appealable in federal court.
Yeah, because when it's denied, it means the case is still ongoing. You don't have a final judgment in the case. The case is not over. But in
Correct.
California, in a California state court, you would have an immediate right to appeal because you have a right as a defendant to get that SLAPP action against you out of court. And if the trial judge won't do it, then the Court of Appeal needs to do it.
And the reason for that, Tim, is because this anti-SLAPP statute provides a real substantive remedy, and that is total immunity from suit. Okay, let's set aside the other remedy, which is getting your attorney's fees paid for, right? If you win on an anti-SLAPP, the fact is that you get total immunity from suit. Not all anti-SLAPPs, not all roses, by the same name are a rose, right? They might smell like one. They don't necessarily have the same thorns. California's rose, in the form of an anti-SLAPP statute, has a lot of thorns, meaning it provides you with a complete immunity to suit as a defendant, and it also gives you an entitlement to attorney's fees, because you were dragged into court over something that was protected activity and that should not have been in court in the first place. Well, interestingly, the Ninth Circuit did not address, the Erie Doctrine didn't address whether federal and whether anti-SLAPP belongs in federal court. It expressly assumed for purposes of this case that it does belong in federal court in order to reach the jurisdictional question of whether the anti-SLAPP denial can be immediately appealed under the collateral order doctrine. And again, the Ninth Circuit said, no, it cannot. And what I find this case to be the most surprising decision so far in 2025. I know we still have a couple months left, so we could still be surprised, even more. But this is to me the most surprising, and it's because it reverses years and years of Ninth Circuit precedent, not just several years. We're talking 22, 23 years of Ninth Circuit precedent, right? Where the Ninth Circuit decided in the Batzel case, I think back in 2000, I want to say 2003, Batzel v. Smith, that these denials of anti-SLAPP motions, California anti-SLAPP motions, are immediately appealable. And why am I so surprised? It's not just because it walked back decades of precedent in the Ninth Circuit, or that it has further deepened the circuit split on this issue, on this question, but it's also because it's a significant shift by eliminating the right of an immediate appeal in federal court from a district court's denial of an anti-SLAPP motion. Beyond creating a circuit split, we're also, there's also a great deal of uncertainty that is created for litigants and for parties from this decision. And that is something that I have to believe that the judges on the en banc panel were aware would happen, okay? That uncertainty that this decision creates for future cases. The ruling has created some confusion and a debate even among Ninth Circuit judges about whether, to your point, Tim and Jeff, whether California's anti-SLAPP statute can even be applied in federal court at all. This has significant implications for future litigation strategy because plaintiffs or claimants in California or counterclaimants in California may now prefer federal court to avoid the potential delays caused by immediate appeals from denials of SLAPP motions in state court. So what we're talking about is forum shopping, right?
Huge forum shopping.
Yeah.
Huge forum shopping. Johnny Depp was fully aware that Virginia's anti-SLAPP law was much weaker than California's. And so that's why he chose to file his lawsuit against Amber Heard out there in Virginia. And the same is going to happen here. The answer here is we need Congress to take a second look at Representative Raskin's federal anti-SLAPP bill, make it federal, and be done with this debate.
Jeff, I have to agree with you. I've been a proponent of a federal anti-SLAPP statute since I can remember. But I could say beyond the forum shopping concerns, Jeff, what we're talking about here is on the subject of whether anti-SLAPP applies in federal court. I want your viewers and your listeners to know that we can actually gain a glimpse into a division amongst the conservative wing of the Ninth Circuit in the Gopher Media case. You have to look at the separate opinions, okay, the concurrences. And you see my circuit judge, Judge Callahan, joining with Judge Bennett, and they write separately, and they state that California's anti-SLAPP statute does apply in federal court. Well, that's a position that Judge Callahan has very consistently taken from the time she's been on the court, right? Now, 22, 23 years she's been on the court. She has always taken that position. Judge Wardlaw has taken that position. They've even joined together in decisions where they say, the federal courts must hear California anti-SLAPP motions, right? Because it's a substantive statute. It's not a procedural statute under Erie. But what's interesting here is, Judges Bress, Collins, Lee, and Bumate, all on the en banc panel, and all appointed by President Trump, right? In his first term, Judges Bress, Collins, Lee, and Bumate, suggesting that it does not apply in federal court, and that the California SLAPP, is procedural, that it's not substantive.
That's the dividing line, right? Is
Yes.
Whether it's procedural or substantive. And if it's procedural, then under Erie, it has no place in federal court.
Right. And what's interesting is I looked at the panel composition of Gopher Media, and in that case, you see Judge Van Dyke is part of the en banc panel. But interestingly, I don't see that Judge Van Dyke has joined any of the separate opinions, right? So we don't yet know what Judge Van Dyke's position is. And while I think there's a lot of commentators saying, "Oh, look, the handwriting is on the wall. The anti-SLAPP is dead in federal court in the Ninth Circuit, at least." Well, I think it remains unclear Not only because we don't know what Judge Van Dyke's position is, that's not the reason, but there are 18 active service Ninth Circuit judges who are not on this en banc panel, right? And a multitude of other senior judges in the Ninth Circuit are not on this panel. And so we don't know what their positions are on it. And so it's very much a numbers game. You have to, when you draw an en banc panel, you don't know who you're going to draw. You don't know which judges are going to be on that. It's a petite en banc. It's not all 29 active service judges, right? It is 11 judges selected at random, except for the chief judge who's on every en banc. So you have 10 judges selected randomly, and they could be, any of those active service judges. Sometimes they could even be senior Ninth Circuit judges.
Okay, and so Jimmy, you fall in the camp that there is a substantive component to the anti-SLAPP law. Does it? So would you have joined? Would you have joined the majority here, but not the concurrences?
I think that I am of the view that it should be immediately appealable. That the Ninth Circuit got it right the first time, that it shouldn't have broken rank with its precedent. Now, on the question which this court didn't answer, which the en banc panel didn't answer, which is whether it belongs in federal court, I tend to be in favor of Judge Callahan and Judge Bennett's position on this, and Judge Wardlaw's historical position on this, which is that it does belong in federal court. It is a substantive statute. It provides substantive immunity from suit. I can't think of more substantive, valuable, remedy provided by anything or anyone in the world than substantive immunity from suit.
Yep. To avoid discovery, to avoid a trial, to have the right of immediate appeal. That's a unique creature under the law, and it's an expression by the California legislature of substantive rights that belong to people who are sued for engaging in First Amendment activity.
Well, those things are undoubtedly valuable, but are they substantive? I mean, there are a lot of procedure, the right to attorney's fees, isn't that, and costs. Those are procedural rights, I believe. They're not substantive, causes of action. But I mean, compare it to a qualified immunity, where the officer is not liable, even if he did it. He's not liable unless there was a published decision on that point, or even better, because this comes up all the time in SLAPP cases, litigation privilege. If you did it, if the defendant actually did make the defamatory statement, but it was in the context of a judicial proceeding, it doesn't matter if he did it, because there is a substantive right under that litigation privilege. But it's not so for other things that are not qualified by litigation privilege. If you can show that there is a minimal merit to the claim, you are not protected by the anti-SLAPP statute. I think that makes it different than qualified immunity or litigation privilege. Now, but I take your point that it's certainly valuable, but I think it can be distinguished. I'm in the camp that it's procedural rights, but I agree that it does create lots of problems, forum shopping, and vastly different asymmetry. But it all bleeds into the litigation shopping.
I love the comparison you make to qualified immunity and denials of qualified immunity motions, right, in federal court, which are immediately appealable. I mean, we are talking about really, in large part, an apples to apples comparison here, and so I do think that these are important questions. These are difficult questions. I don't want to make it sound like these are easy questions, right? These are difficult questions. However, I think we as practitioners, as officers of the court, have the obligation to bring these kinds of branches on other parts of the tree to the attention of the Ninth Circuit, where maybe qualified immunity isn't entering into the conversation and into the discussion. But what we can do is draw those comparisons and say, look, you don't want to create a schism in the law. You don't want to create this kind of inequity, right, that occurs where on the one hand, you have qualified immunity appeals coming up, and then the substantive immunity offered through anti-SLAPP protection, well, that's not apparently worthy enough for an immediate appeal. Of course, all of this goes away this whole conversation goes away if the Ninth Circuit determines that, under Erie, it's a procedural device and it doesn't belong in federal court in the first place. So we wouldn't even get to the question of jurisdiction on appeal.
Yeah. Okay, we're down to our last few minutes of time, and we wanted to get to some of the interesting laws in 2026. And Jimmy, you wrote an article about this that I'll share in the show notes. Remind me, was this an OC Lawyer magazine?
Yeah, OC Lawyer.
Yeah.
It's an annual article.
Yeah. So tell us, give us the updates. What do we have to expect coming down the pike effective January 1st, 2026?
Well, thanks, Tim. Yeah, it's a fun article that they ask me to write every year on what are the interesting new laws or the most impactful new laws that are going to take effect in the new year. This, of course, starting on January 1st, 2026. Our California Governor, Gavin Newsom, has signed several new laws impacting Californians and businesses. And I thought it would probably be interesting to highlight just a handful of these. The first is AB 49, Assembly Bill 49, and that's immigration enforcement at schools. And what this new law does is it bans school officials and employees of a local education agency from allowing an officer or an employee of that agency from conducting immigration enforcement to enter a non-public area of a school site for any purpose without being presented a valid warrant or court order. It also directs, this particular new law directs school officials to request valid identification from the officer or employee of an agency conducting immigration enforcement seeking to access that non-public area.
I'm sorry to do this and ask a question because I know Jeff's got a hard stop in just a couple of minutes, but these kind of laws, it makes me wonder, it is lamentable and frustrating when, when ICE will come to our California courts and enforce immigration law at our courts, because then that's chilling to our court system. But I wonder if all of the, it seems like there are a lot of state actions that make it difficult for ICE to do their job in other ways that are less impactful to our other institutions, that it's leaving ICE a precious, scarce opportunity to enforce the laws other than taking these more onerous actions.
Let me just get through some of these others too. I know you're interested in these others. So one is Assembly Bill 656, and that's deleting your social media account. Assembly Bill 656 requires social media platforms to provide a clear and conspicuous button that allows for users to delete their account and gives users the necessary step to delete their account and personal information if they simply click on that button. Okay. The other one is Senate Bill 627. That is no more facial coverings for immigration enforcement agents. And this is kind of a dubious one from a federal constitutional lens, because it's known as the No Secret Police Act. That's what it's titled. It makes it a crime for a law enforcement officer, including federal officers, or those acting on behalf of a federal law enforcement agency, to wear a facial covering. I'm not so sure that a state can make that kind of legal pronouncement and to that matter, criminalize a federal law enforcement official's behavior. So it'll be interesting to see what the challenges are brought to this particular law. Senate Bill 640, just in the few seconds we have left, this is a direct admission to California State University. Some of our high school students no longer need to apply to get into Cal State universities and schools around the state. If you meet a certain GPA threshold and you've taken and completed certain A through G coursework in high school, you will receive an admission opportunity at those schools around the state, with a few exceptions. The good Cal States, the one that we call good ones, those aren't participating in this program. And you could probably name which ones those are. Senate Bill 576 is the last one I wanted to bring to your attention. And this is one that I think we all will love and agree on, no matter what our politics and ideologies are. It's no more loud ads. It prohibits video streaming services from transmitting the audio of a commercial louder than the video itself, right? My only problem with this law is it doesn't go into effect until July 1st, 2026. I wish it went into effect immediately. So here's one where, I think we all, to end on a positive note, we can all agree on is a good.
We finally have unanimity. That's right. All right. Well, thank you, Jimmy, for that roundup. We're going to post that link to that OC Lawyer article, your annual article of it. What's the title, the running title of it?
Oh, it changes every year.
Okay.
A new year, new laws. I don't know. I try to come up. If your viewers have suggestions for titles, I'm kind of out of ideas on what to call this article every year. So,
Okay.
if
But
you can think of something fun or whimsical, please contact me.
Yeah, but until July 2026, keep your finger on that volume button and keep your fingers ready to plug in your ears for when the commercials come around. But otherwise, then we'll finally be safe from those obnoxiously loud commercials. Well, Jeff and Jimmy, thank you for the conversation. That's going to wrap up this episode. If you have suggestions for future episodes, guests, topics, please email us at info@kowalpodcast.com. In our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
See you next time.
Thanks again, Jimmy.
Thanks, Jeff. Thanks, Tim.